Well, okay, and here we are, and I'm George Yates, and this is Justice for All, and we're going to be here for the next few minutes discussing, tax stuff. It's tax time out there. What's today? March the 28th. And within the next 18 days, many of us will be having to file, if we don't get extensions, we'll be having to file our returns by April 15th, pay our minimums due, and that's all that kind of good tax stuff that's coming up. Some people out there scrambling and going out and buying their TurboTax or doing it themselves or getting all their materials together and taking them off to their accountant and getting there. And hopefully lots of people, of course, have already filed because they want to get their refunds. We have an expert on today, a tax expert for the wealthy. I'm sure he has tax information for everybody, but he specializes in high wealth individuals and assisting people protect their incomes through asset protection trusts and offshore accounts and all kinds of interesting ways for to defer and delay and avoid taxation. So I'd like to welcome to the show Jeff Verdon.
Good morning, or I guess good afternoon where you are.
Yeah, good afternoon. Now, yesterday I spoke to you on the phone, Jeff, and you were in San Francisco. Is that where you are now?
I'm in beautiful San Francisco, sunny, bright, just gorgeous.
Oh, good. Well, good for you. Well, listen, I for those of us that are listening to the show today, it is tax time, and you are an attorney, right?
I am.
And are you a certified public accountant too, or are you somebody that just is a numbers whiz and can tell people how to do their taxes and save money?
Well, after I graduated from law school, George, I went back and got a master's in laws and taxation. What that means is we study the tax code for a solid year, and so when we give out tax advice, it's based upon the notion that if the IRS comes in and challenges it, that as lawyers we're advocates and we're happy to defend our position and litigate if we need to.
And are you with a group of lawyers in California?
I have what you would describe as a boutique law practice. We've got 3 lawyers in our office in Newport Beach. We work with an attorney in the Las Vegas area because we do a lot of Nevada structures. They've got great LLC and trust law. And then we have our secret weapon, a lawyer out of Miami named Jerry Hesh. He's a brilliant income tax and estate planning lawyer. He teaches taxation, and if he can't figure out a solution to a problem, it can't be solved.
So, where do you start when you're trying to when people come to see you? I mean, it's generally the more high wealth individuals that you represent.
Well, our clients are typically the self-made entrepreneur, business owner, or retired individual. We don't handle the third-generation Pasadena folks. They go to the big firms in downtown Los Angeles. So our clients, are looking for not only our tax advice, but they're also looking for us to help them put together the strategic team to help them not only do the planning, but then make sure it's administrated properly. And as Hillary Clinton once said, it takes a village. So today, particularly with affluent families and business owners, it really does take a group of folks to help them, manage their affairs. And since most of our clients wouldn't know who to pick if they had to pick them out of a lineup, we help them create those relationships. So I guess you could say we're kind of this consigliere to the families and help them not only do the planning but also pick the team that's going to help them administrate it all.
What are the worst and best tax strategies that you use for? I'll say, what are the best tax strategies that you use for your typical individual that's coming to you for advice, or individual, perhaps his company?
Well, I have a little bit different take on what keeps us up at night. When people come in to see me, again, they're successful. They built up a nice nest egg, and now they want to protect it. So what we want to emphasize, because 95% of all the world's lawsuits are filed in the United States, and in 2013, over 50 million lawsuits were filed in this country, the thing that keeps us up at night more than anything are the risk of loss to lawsuits. So before we get into an income or an estate tax strategy, we want to emphasize the importance of building the firewall protections around our clients' assets. So if they do wind up in a lawsuit, and it happens, we're the most litigious country in the world, then at least they have the ability to slow down the plaintiff, get the parties to the bargaining table, and get a case settled quickly and cheaply, because the plaintiff who's going to sue our clients are going to have a very, very difficult time in reaching their assets. So once we button that aspect of their planning down, then we can move into income tax planning, estate tax planning, and the like.
Well, how do you do that? How do you actually put them in a corporation and then that's owned by another corporation and then move the money offshore or something to that effect, to where if they try to sue it, they can't reach it?
Well, nothing that Byzantine. The whole idea behind asset protection planning is to create a situation where the other side has doubt as to collectability. And there's a number of we had a very big toolbox, and there's a number of both domestic and foreign strategies that we employ. But we have found I did my first asset protection plan in 1986, so I've been at this a while, and I find what works the best is if a client has a lot of liquidity and they want to protect that liquidity from a creditor, to put it into an offshore asset protection trust, a tax-neutral offshore asset protection trust. There's a big misunderstanding out there about people who use offshore in their planning. The IRS wouldn't print all the forms that they have for people who are engaged in offshore activities if going offshore were illegal. IRS doesn't care that you go offshore. You just have to tell them about it. So in the 20-plus years that I've been setting up offshore trusts for asset protection, we file all the forms. Our clients tell the IRS what they're doing. But then if there's a lawsuit, the assets that the client may have in the United States are moved overseas into a bank or a brokerage firm that has no U.S. presence. And then if a creditor gets a judgment against my client, they have to pursue those assets overseas, and they're unlikely to reach them, because at the time we set up the structure, there were no creditors, and therefore there were no fraudulent transfers. And that gives me the ability to sit down with an opposing lawyer and work out a settlement, because no lawyer, you're a lawyer too, George, no lawyer is going to pursue a claim if they're not going to recover anything on that claim. That's why homeless people don't get sued. They commit torts and batteries and property damage all the time, but there's nothing to recover. And we can do that legally using the various structures that we have at our disposal.
Now, you discuss how did the Anderson case change the asset protection trust, whatever this vehicle is that you use?
Well, let me just take a moment for your listeners' benefit and explain what the Anderson case was about. There was a couple in San Diego that set up a Cook Islands Asset Protection Trust, and the lawyer who set up that trust had the Andersons serve as their own trustees, which is how most trusts are set up, not for asset protection, but for your estate planning. But what the lawyer did was he gave the Andersons the right to resign if they ever got in trouble. Well, there's an old saying in art industry, George, as you know, bad facts make bad law. So the Andersons were involved in a $20 million Ponzi scheme, and they ripped off the late-night viewers on some products, I think, or some services they sold late night. Well, when the Federal Trade Commission came in and sued the Andersons and got a $20 million judgment, what did they do? The money was moved to the Cook Islands, and they resigned as the trustee. Well, then when they resigned as the trustee and when the court ordered them to bring the money back, they said, "We can't bring it back, Your Honor. It's legally impossible for us to do this." Now, there is a legal impossibility defense in the area of contempt of court. If the judge orders you to do something and you legally cannot do it, they can't hold you in contempt. But if you create the legal impossibility for which you're now raising the defense, that doesn't work. So the court sent the Andersons to the Gray House in Las Vegas, just outside of Las Vegas, until they brought the money back. Well, eventually, the money didn't come back. About 6 or 8 months later, they worked out a deal with the Justice Department and the Federal Trade Commission, signed some papers assigning all of their interest in the trust to the government so they can get the money. The government goes over to the Cook Islands and presents these papers and said, "We would like the money in the trust." Well, because of the law in the Cook Islands and the way the trust was drafted, there's a concept called duress. And if the money's being asked for from the trust under duress, and court order is one of those indicia of duress, then the Cook Islands law, and thus the Cook Islands court, would not allow the trustee to turn the money over. So even though, and by the way, the Andersons got out of jail because they had signed these papers for the Federal Trade Commission.
How many months did they do in jail before they?
About 6 months.
Oh, my God. Okay.
And what doesn't get reported about the Anderson case, this was back in the early 90s, so a lot of laws developed since then. But the Andersons got out of jail. The Federal Trade Commission never got their money because under the Cook Islands law, once you set up the trust and the money is in the trust for 2 years, even if it's a fraudulent conveyance, the trust can't be broken. So as far as I know, the money's still in the trust, and the Andersons are out of jail, and I'm not sure how that money is being dispersed because that's confidential information that doesn't get disclosed by the trustees. But that was a case. It had the lawyer not put the Andersons as trustee in the first place, the Anderson decision would never have happened. So it was kind of poor lawyering. But back in those days, this was still the early stages of doing these offshore trusts, and we were kind of finding our way, and that was certainly not the way you wanted to set it up. So the Anderson case made the papers, and we all, the critics said asset protection trusts are over. But the reality is, and there was a very good article in the New York Times back in December of 2012, featuring the Cook Islands Trust as one of the preeminent places to protect your assets, and it's still alive and well in a very robust industry.
And so this is that what you probably do specialize in the most, or what is your what would you say you and your firm specialize in the most to protect the assets of the wealthy?
Well, it's a good question. I started out doing all domestic asset protection planning because in those days we didn't have the advent of the offshore trust. But I found that judges don't always follow the law the way the law is written. Often they want to achieve a certain result, and there's great vagaries in our legal system. And my clients would like to have more predictability of results. So when I moved into the offshore trust arena, it gave me the ability to achieve what we lawyers call jurisdictional arbitrage. What that fancy word simply means is once a lawsuit is threatened, the money can be moved out of the United States legally because it's in the trust to begin with. And once those assets are 10 miles outside of New York Harbor, then the court doesn't any longer have the ability to tie those assets up. So when I sit down with an opposing lawyer who's thinking about suing my client or already has sued my client, and I explain what we did way before they ever came into my client's life, this lawyer has no interest in pursuing his claim and will settle the case for pennies on the dollar. And that's been the experience that we have enjoyed in our firm over the last 15 to 20 years in doing these offshore trusts. So given the choice between doing a domestic trust, and we can talk about the 15 or 16 states that now offer domestic asset protection trusts, but there are still problems with domestic planning, and if a client has enough money to matter, he's going to want to use the more muscular, robust foreign asset protection trust.
And so the domestic asset protection trust is one where you move it into a trust that's here in the United States before it's moved off, but it's protected. You can still move it. It's just, even though it's here, they still can't get to it.
That's right. When you put your money into a trust, you no longer own the money. It's owned by the trustee.
Do these people anticipate litigation? I mean, is it something where somebody's done something and they think, I mean, it kind of looks like somebody's actually maybe why they're anticipating litigation over these funds. Is it something where they're coming to you and they're saying, "Hey, I think somebody might be coming to coming after my money, so let's move it now before any lawsuit is filed"?
Well, they do it for the same reason that people incorporate or they form limited liability companies. If you go into if you're a surgeon, a thoracic surgeon, or you're an anesthesiologist, or you're a trial lawyer, you're in a high-risk business, and you cannot buy enough liability insurance to protect yourself, then what do? Either you leave yourself exposed, in which case many people would get out of that business, and we would lose great lawyers, great doctors, great business people, or you level the playing field, George, by setting up these structures so if there is a lawsuit in the future, and as I say, 95% of the world's lawsuits are filed here, and over 50 million lawsuits were filed in 2013, so it's just a matter of time
I see.
if you're in a risky area that you might get hit with a lawsuit.
Okay, I'm getting it.
Get it?
This is not where the money itself is the subject of the litigation. This is where you got somebody that's just in a type of business where they can't really protect themselves through insurance, like a doctor, a lawyer, and where they can't incorporate and protect themselves really.
Well, even if you incorporate today, George, many jurisdictions allow the corporate veil to be pierced.
Of course, yeah.
People say, "Well, I have liability insurance. Isn't that enough?" Well, it depends how much liability insurance you own versus how much the lawsuit might be. I like to say liability insurance carriers cover you if you fall off the roof, but not necessarily if you hit the ground. And liability insurance is a 1 year to 1 year arrangement with the insurance company. It doesn't necessarily mean they're going to insure those risks in the future. So this is an excellent way, as I say again, to level the playing field and to give people who have accumulated wealth the ability to stay in that industry, to stay in that occupation or that profession, and protect themselves.
I get it. So what else is, let's see, you also have some kind of estate planning for women only. Is that something you specialize in? Like, do women have specific kind of estate planning that they need to worry about as opposed to men?
Well, George, that 9 out of 10 marriages, the women will survive the husband. And if they're going to survive the husband, they need to know what to expect if they're the sole breadwinner or if they're the sole survivor. And most women, I find, are not equipped and haven't been. It's just about having the right education. Many women and many men are illiterate when it comes to legal and financial matters. So when I speak on a number of cruises each year, and one of the workshops I do on the cruises is estate planning for women only, no men allowed. And we don't let the fellas in the room, because by letting the fellas in the room, the women won't ask questions. So by keeping the fellas out of the room, it's just the gals and me, we get into all these areas where women really need to know about this information, from the very basic to the more sophisticated. So I've written a book called Estate Planning for Women Only. Your listeners can get it on Amazon.com. And we donate the proceeds to the Wounded Warriors Foundation, because that's a charity we support. But it's a quick read, and it's a good primer for any woman who out there who's really interested in this arena, in this knowledge, this information, and doesn't quite have it available to her at her fingertips.
Well, so for any women that are listening to the show today, or for men who are helping their women set up a trust, what is what's the top thing that a woman needs to think about when she's estate planning?
Well, I think the number one thing is life insurance. George, I never met a woman who thought her husband was overinsured. And so a lot of fellows don't like to buy life insurance, either because they don't like to pay for it, or maybe they're just uncomfortable getting it. But one of the major changes in the financial industry has been in the area of life insurance. In the old days, when somebody wanted to buy life insurance, there was only one way to pay for it: cash. They could pay it annually, quarterly, monthly, but they had to write a check. Today, if a person wants to buy a life insurance policy, they can go to a bank and they can finance the premium. So if you wanted to buy a policy for your widow, for your spouse, if she became a widow, you can borrow the premiums from a lender, pay 2% or less for the money, interest only, and then when you passed away, the insurance company wrote 2 checks, one to the lender to pay back the loan balance, and one to the beneficiaries of the policy.
Oh, my gosh.
Well, this completely liberated it transformed the way that life insurance policies are purchased in this country today. And so people now can have all the insurance they need or want and finance it. And this is one of the areas that a lot of women, when I speak to the women groups, don't understand. But once their husbands realize this, then they're much more willing to purchase that life insurance policy, particularly if it's a his, mine, and our situation. You get a lot of second marriages where she has kids and he has kids, and they're trying to figure out how to leave their assets. Many times the wife is not that much older than the kids, adult kids. And so by the husband leaving an insurance policy in a trust for his kids, she's not going to feel like the kids are looking over her shoulder every time she spends $1 out of the estate plan, and therefore creates a much more comfortable situation. And we talk about these sorts of things in these workshops I do.
Well, that allows you to leverage an extraordinary amount of life insurance. You can, by borrowing the money like that, you can get a lot more life insurance, a lot more coverage, and then you're still protected because it's just going to pay back the loan.
Exactly. Let's assume you're getting 4 or 5% on your investment portfolio with your investment advisor, and you can borrow the money at 2%. So why would you take money out of your portfolio to give it to the insurance company, which, by the way, are after-tax dollars, so you've got to earn twice the amount that you're paying in premium because you have to pay tax on the earnings. Instead, you can borrow the money from a lender, pay the lender 2%, keep your money in the portfolio earning 4 or 5 or 6% or whatever you're able to get today, and you're also building up cash value in the policy. So it's just a more intelligent way of purchasing insurance today when you leverage it. It's not for everybody, but for those people who may want to change their insurance portfolio or add to it or buy some for the first time, they ought to talk to their agents about premium financing. And if they don't know who to talk to, I can certainly help them get introduced to the right folks.
So for 2015, what are the major tax law changes that anybody that's listening to the show might not know about?
Well, the one thing that people need to keep in mind is that the states are out of money, so the states are starting to look at raising their income taxes. In California, where I live, our tax rate is up to 13.3%. So don't ignore the state taxes. And if people live in a high-tax state, one of the planning opportunities they have, George, is they can form what's called a non-grantor trust, what we call a NING trust. NING stands for Nevada Irrevocable Non-Grantor Trust. And they can put their assets, their real estate assets that are outside of their home state or a business interest outside of their home state or even their portfolio, which they can move to a non-tax state, put it into this trust that doesn't have any state income tax. And as long as they aren't taking distributions out of that trust, they're not going to pay state income tax on the earnings inside the trust. So this is something that people in California want to move out of California because of our high tax state. Well, don't move out of California. Just move your assets out of California, and you can mitigate some of your income tax liabilities.
If you just joined us, I'm George Yates, and this is Justice for All, and we've been speaking the last 30 minutes or so with Jeff Verdon. He's a tax lawyer and estate planning specialist from California and practices all over the country, really helping people. We're going to go to a short break here, and we'll be right back for the next few minutes with Mr. Verdon. Stay with us.
Are you prepared to defend yourself and your family against any threat? Veteran-owned and operated One Shot Trading Post is ready to make sure that you are. Continuing training and classes on defense, survival, and weapons. Full gunsmithing services, special orders and financing available with military discounts. $15 transfers, and One Shot Trading Post is always looking to buy, sell, or trade. Located at 4366 Holland Road at South Plaza Trail, make sure that you're ready for anything at One Shot Trading Post, 463-5893, OneShotTradingPost.com.
RM Designs T-shirt printing and more is located in Smithfield, but serves all of Hampton Roads. They specialize in vinyl designed shirts, apparel, window stickers, cups, and other specialty gifts. They also have rhinestone and embroidery designed apparel, and they offer Pandora-style beads and hardware to create a one-of-a-kind piece of jewelry. RM Designs T-shirt printing and more caters to businesses, sports teams, churches, groups, and family reunions. They also offer a great fundraising package should you be in need of money for a special project. And they also do home parties if you and your friends would like to get together and make your own creations. RM Designs T-shirt printing and more can be reached at 757-255-9140. That's 757-255-9140. Email them at rmdesigns11@aol.com or find them on Facebook at RM Twisted Designs. You can also place orders directly off their store at storenvy.com/RM Twisted Designs.
Hi, this is Greg Bigoveris. Join me for Sports Scene each Wednesday from noon to 1 right here on News Talk 1650 WHKT. You can also hear the show on TuneIn as well. We will talk to local, regional, and nationally acclaimed sports guests, and we'll interact with our audience as well at Greg Bick on Twitter. Sports Scene, Wednesdays from noon to 1 right here on 1650 AM.
Denby Baptist Christian School is now enrolling students for the upcoming 2015-2016 school year. Denby Baptist Christian School offers a quality Christian education for students in kindergarten through the 12th grade and an early learning center for preschool children ages 2.5 to 4. DBCS is a ministry of Denby Baptist Church located in the Oyster Point section of Newport News, offering education marked by a biblical worldview, academic excellence, extracurricular activities, and affordability. Denby Baptist Christian School offers daily Bible classes and a weekly chapel service. Call and schedule your tour at Denby Baptist Christian School, 13010 Mitchell Point Road, Newport News. Call 757-249-2654. The mission of Denby Baptist Christian School is to educate the mind, nurture the soul, and shape the character of each student in a Christ-centered environment based on the truth of God's Word. Online at dbcs.org and dbcs-kids.org.
If finances are holding you back from enrolling your kids or grandkids in private Christian schools, call the radio station at 488-1010. We have a partnership program with several schools on the peninsula and the south side that allows us to offer a 35% discount off tuition for preschool through the 12th grade. Give us a call today at 488-1010 or visit our website at tuitionsolution.org. Did we mention we added daycares to the site? tuitionsolution.org.
Okay, we're back with Jeff Verdon. I'm George Yates. This is Justice for All. And Jeff, what is I know that, I'm a lawyer. I know what a trust is. I think a lot of people know what a trust is. But for people that are estate planning, and you do a lot of that, when do people want to set up a trust? And what kind of different kinds of trusts should people consider when they're doing estate planning? Hello? Did we lose him? Hello?
Hello?
Oh, okay. Jeff, did you hear that last?
I'm sorry, I did not.
Oh, okay.
Please.
Let me. A lot of people. I know what a trust is. Some people know what a trust is, but you do a lot of estate planning, and almost every type of estate plan. My guess is that people want to put money in trust. Why do people want to set up a trust, and what does it do, and what kind of different kinds of trusts can people set up if they're trying to plan their estate?
Well, George, there's two kinds of trust. There's what's called a testamentary trust. Those are trusts that are set up under your will. And if you set up a testamentary trust under your will, it just means that the property is held in trust for a longer period of time. Generally, it's done to protect the beneficiaries against lawsuits or divorcing spouses or any other sort of liability claims. But whenever you have a trust set up under your will, it has to go through a process called probate. And probate involves a court, and probate involves a lawyer and a judge. And if it involves a lawyer and a judge, then it's going to cost money. So what a lot of people will do is they'll set up what's called a living trust or an inter vivos trust. And that's a trust where it's an agreement between the person who sets it up, called the grantor or the settlor, the trustee. Generally, it's the same person with a revocable living trust, and then the beneficiaries. And when you have your assets held in a inter vivos or living trust, and then death occurs, then you avoid the process of probate. So unless the family is really dysfunctional, kind of like the Anna Nicole Smith saga that you saw playing out a few years back when she passed away, but most families don't need to have a testamentary trust. A living trust will do just fine, and then you get to avoid all those expensive lawyers' fees. Now, a lot of lawyers will set up testamentary trusts. Why? Because they get to probate the estate when the individual passes away, and that's their retirement fund. So if any of your listeners have a will which converts into a trust, they may want to go back and revisit that with their attorneys and ask them, why do I have a testamentary trust and why don't I have a living trust? Now, the living trust that I just described only avoids probate, and if either one of the spouses becomes legally incompetent, then the other spouse can take over, or some successor trustee can take over and run the trust. So it avoids a very nasty process called a guardianship or a custodianship. But it doesn't save taxes. So if your listeners out there have estates that exceed $5 million, right now the government will let you die with an estate of $5 million. It's actually $5,430,000 before you pay any death taxes. So if the estates are larger than that, then people want to think about some of these more specialized trusts that we use. And we developed a trust a few years back called the HYCET Trust, HYCET, and that trust stands for Have Your Cake and Eat It Too. And the Have Your Cake and Eat It Too Trust allows your listeners to set up a trust, make a gift of their assets to the trust so it's out of their taxable estate, it's away from their creditors, and all the appreciation in that trust grows outside of being subject to death taxes. But if they get donors' remorse, if they want to get the assets back, if they get mad at their kids and grandkids and they want to undo it, this particular type of a trust allows the trustee to give those assets back to the donor. So it creates a lot of flexibility, and we do a lot of those trusts for our clients. It's called the HYCET Trust.
And it's actually called that, the Have Your Cake and Eat It Too Trust, or is that just a funny name you came up with?
Well, it's a name that I came up with because of when the law changed back in 2011, and I checked with an intellectual property lawyer friend of mine, and that name had not been taken, so we own the federal trademark of that name.
But any lawyer could set up that trust themselves, right? And this under what code section or IRS code section or I mean, if someone's when you set up that kind of a trust, how would somebody do it if they just, let's say, didn't get your services? But
well, I would just refer them to Private Letter Ruling 2009-44002, or they can contact my office, and I'll be happy to connect the dots for them and tell them what needs to be in the trust, and they could do it themselves.
Well, because ordinarily when somebody gives money to the trust, one of these, you call it an intra vivos trust or a living trust, it's a revocable trust, right? Isn't that what it's another name for it?
Yeah, if the revocable trusts or revocable trusts are give the person the power to reclaim that, but it's in their taxable estate. But for people who want to make gifts, back in 2009 when the Great Recession happened, people lost a lot of their wealth. And so the notion of giving their assets away to their kids and grandkids in trust and then not being able to reclaim it if they have another emergency was just totally unacceptable. Well, when you read this private letter ruling and its progeny, you figure out that you can set up a trust in a qualifying jurisdiction like Nevada. It's one of the places we set these up. And you can make the gift. It's under the ruling, it's considered a completed gift, but the trustee can be given the power to return all or some of those assets to the grantor, to the donor, and so you've got that flexibility built into the trusts. And so when we do gift planning for our clients, most of our trusts are set up this way, so if something happens in the future and the grantor needs the assets back, he can get them. Now, most people are not going to invoke this provision, but they like to know they have the flexibility of having it in the trust.
Well, and it's a lot easier when you're trying to talk your wealthy granny into giving away her money, and she's worried about her old age and running out of money, as so many older people do, even though they have plenty. That's a pretty nice, reassuring thing to say to that person. Say, Granny, you're getting the money out of your trust, or out of your estate. You're going to be able to, and you can still get it back. I mean, how beautiful is that?
Exactly.
Now, do you have to set it up in Nevada? I mean, you're saying you can't just set this kind of trust up in any state.
In order to qualify for this type of a treatment, you have to set the trust up in a state that has what's called asset protection or self-settled spendthrift trust law. And there's 16 states that have this kind of law, and Nevada is one of the few states that has no creditor exception carve-outs, as it's called. So it's in my judgment, the best state to set one of these trusts up in the country.
So you can send your. Now, what is it? How is gift tax computed on a trust like that? If someone gives money to that trust, is not subject to that lifetime gift limit that people are required to follow through with?
Well, let's say, George, you came in to see me and you wanted to give away your $5 million exemption because why would you want to do that? Because if you give the $5 million away now, in 30 years, if you're getting 10% return on that $5 million over the next 30 years, that's $96 million of value that you've transferred out of your estate for which there will be no estate tax for many, many generations. So it's significant. So if you gave up to $5 million into a trust like the HISET Trust, then it's out of your taxable estate, and when you die, you'll pay no estate tax on whatever that grows to. But let's say 10 years after you set the trust up, you hit some financial reversals, and all your money is gone. You need to tap into that trust. You can tap into that trust, and the trustee can give you some or all of the money that's in that trust, and still have it out of your estate. So it's a very flexible way to make gifts, where in the past, the only way you could make a gift was to give it away, and you had no way to get it back.
Now, when you take that money back out of the trust, you can just pull the principal out. If you pulled the $5 million, and I guess you would pay taxes on the other money if you pulled it back out.
No, you wouldn't pay any gift tax on the money you got back, because that was your money originally.
Right.
You might pay some income tax if part of the money that came out of the trust was what's called distributable net income, DNI. But if you're having to tap into the trust to get money, you probably don't have an estate tax problem, and so it's probably going to be a tax neutral thing. But even if you had some taxes to pay, the fact that you can recapture that gift means a lot to people who are looking at doing this sort of planning.
What other kinds of trusts do you set up for people? What about the kind of trust where, you want to leave it to one of your black sheep children, and you don't want them to spend it, or you want to? How do you set up that those are spendthrift trusts, aren't they?
Right.
And you set those up for people too, right?
Well, George, you raise a very important question and concept. 20, 25 years ago, many people set up irrevocable trust for their kids, for their infant kids or their minor children, and at the age of 21 or 25 or 30, a large chunk of money comes out of the trust, because in those days that's the way they were set up. But now that their kids have grown up, the idea that they'll get all this dough coming out of the trust is just frightening to many parents. But because the trusts were set up as irrevocable trusts, they can't be changed. And so in a couple of years, when they get the call from the lawyer saying, oh, by the way, in 2 or 3 years, your 20-year-old college-bound student is going to get a big chunk of money out of the trust, the parents pull their hair out of their head. Well, we have a solution to that. It's called a do-over trust. There's a concept now in the law called decanting, like decanting a bottle of wine into a decanter. You can actually take your trust, if it allows you to do so, and move it to a number of states, again, like Nevada, and you can draft a brand new trust with the provisions that you want in the trust. And by the way, in the state of Nevada, that trust can stay in existence for 360 years. So that's a lot of generations you can cover without it coming out to the kids. They can get income and they can get principal based upon certain standards, but they're not going to get all this money at one distribution. And then you can decant the broken trust or the old trust or the trust that has the unwanted provisions into this new trust, and then the new terms of the trust will apply. So it's like being able to make a change, an amendment to an irrevocable trust, which in the past you couldn't do. So if any of your listeners have these older trusts and their lawyer has told them, look, it's irrevocable, we can't change it, they now have a solution to that. It's called decanting a trust, and it's being done quite a bit over in the country because of people who have set up these older trusts that they now want to make these changes to.
And just to repeat that, what you're doing is you're setting up an entirely new trust in another state with new terms. And by decanting, you're basically just pouring the assets from the current trust into the new one.
Exactly, and it's 100% legal.
And Nevada, once again, is your favorite state to do this in.
That's correct. They have very good decanting laws, and in fact, in Nevada, it doesn't even require notice to the beneficiaries if you don't want to tell your kids and grandkids you're doing this.
When you set up a trust, now a trust requires a trustee, right? Who decides what is done with that money upon the death of the person? How do you do that? Who is the trustee?
Well, the trustee oftentimes will be a committee. It'll be a close family friend. It could be all of the children together having a majority vote. It could be a corporate trustee. And if the family has enough money, they can set up their own trust company for their legacy, and the family could be the trustee. And then when a family member passes away, that another family member is appointed. So it's a very broad and very flexible way of deciding how you want the trust assets to be managed.
How do you ordinarily set that up? If you do, you set a trustee, or like you say, with someone in the family, and then what if that person turns out not to be the right person for the trust, or
right,
or dies? You set it up so that there's what if you do this kind of early on in life, and you pick an older, very knowledgeable member of the family, and then by the time the trust vests, that person is no longer around, and you didn't set it up so that it was so the right structure was in place for a successor trustee. What happens then?
Yeah, that's a great question. Let's take the HiSET trust, for example, because that's a trust that's intended to stay in existence for many, many generations. First of all, the creator of the trust, mom and dad, have the power to remove and replace the trustee. So that's always a nice power to retain. They can't replace it with themselves, but they can replace it with other individuals. Number two, when we set up a trust like a HiSET trust in the state of Nevada, we have to use a Nevada resident trustee. So we'll use a trust company that's based in Nevada to do all the administrative functions. And then we'll have a family trustee. That could be a close friend of the family. It could be all the kids. It could be a committee. A close business advisor or confidant. Typically, you won't have mom and dad serve as the trustee, because that will derail our estate tax planning. But you can add different trustees for different purposes, and then if the trustees don't work out, or if they resign, you have successor trustees that will replace them. Mom and dad can be given the power to remove and replace the trustees if they wish to do that. The kids can remove a trustee once mom and dad are gone by a majority vote, and replace it with a trustee that has certain financial criterion that are, it could be a corporate trustee, a bank, a professional trustee. It wouldn't be somebody, that they could just put in there that didn't have any experience.
Do these Nevada trust company, what do they charge for their services?
Very inexpensive, anywhere from $1,500 to $2,000 a year. Whether you put $100,000 in or you put $100 million in, it's not based upon the percentages of assets. And we've been working with several of the Nevada-based trust companies. They're very, very good.
And now, you're setting something up like this. You find yourself the trust company, and that's where they handle it, and then you may have some family members. What happens when you've got family members, like you say, they're all trustees? What if they're bickering over how the money's to be distributed? What's the tiebreaker? How does that work if you've got more than one trustee and they don't agree?
Well, you make it either a majority of the children will be the tiebreaker, or you have the family accountant or family lawyer or someone that the parents have a great deal of confidence in who could be the tiebreaker. And it's good to get your kids involved early in the process, so you can see how they're going to perform, and you'll be surprised, number one, how that brings the family together when you get the family involved in regular meetings, and you give them some of these responsibilities, and they take these responsibilities. You can see how they're going to perform, and it's a good way for the family it's a good way for the kids to get financial literacy, like I talked about before, because they don't teach this stuff in the schools today. That's one of the problems. Our kids graduate from high school and college, and they know nothing about finance, nothing about money, and then suddenly their parents die, and they're supposed to respond like seasoned, intelligent, experienced veterans in this area, and it's just not the case. So it's good to break them in early. It's good to teach them. It's good to have regular meetings, and they're going to pick this stuff up. They're going to learn about it, and they're going to be very, very good at it.
At what level of money is there a cutoff where you say, well, there's not enough money here for us to worry about setting something complex like this up and moving it to Nevada? I mean, is it like you said, $1,500 to $2,000 a year? That if it's only like say $100,000, that could eat into the principal pretty quickly. Right?
Yeah, I see the point of your question, but when you meet with a young couple, and you take their $500,000 or $1 million gift, and again, we're not talking about using funds that they're going to need to pay their regular bills on every day, but when you run out, if you project the growth of let's say a $500,000 or $1 million gift over the next 30 or 40 years at a 5 or a 6% rate of return compounded,
right,
that money is going to grow to be significant, and if they haven't set up the structures to accommodate those larger gifts, and then later on they try to do it when the values have exceeded the gift tax exemptions, then it's very expensive to make those gifts. So it's something that we monitor, and we have those conversations with our clients. And if they're not quite at the point where this makes sense, well, we put it on the to-do list for the next meeting. And this is something also I think it's very important for your listeners. If they haven't been back to see their trust lawyers or their estate planning lawyers about every 18 months to 2 years, then that lawyer doesn't deserve to have their business, and they should change. One of the things I talk to my clients about is Einstein's definition of insanity, and we know that to be doing the same thing over and over and expecting a different result. Well, a lot of people use advisors, CPAs, lawyers that they hired when they first started in the business, or they've had for 15 or 20 years, and they're just not getting the results that they want, and they're confounded by this. Well, if they're not getting the kind of results they want, and they're using the person they've been using for 15 or 20 years, and they haven't upgraded their advisors as they've grown up the socioeconomic ladder, then they need to look at themselves as possibly being the problem. So it's important for people to meet with their advisors on a regular basis, especially their estate and trust lawyers. It's important for people to make sure they've got competent advisors that are able to meet their needs as their net worth grows. And I find when I meet with people around the country, whether it's at a financial conference or on a cruise, very often they've kept the same people, for literally decades, and they're getting the poor planning that they deserve because they haven't upgraded their financial people. So this is a good time to do a check and make sure that they're getting the best advice that they can afford to get.
I've got about 3 questions here, so I want to make sure I get them all in before we run out of time here. First of all, I know, and I'll go through all 3 of them, and so you can address them. First one is, when's your next cruise? And because I think anybody listening might want to be on that cruise, so y'all let us know that one. And how do we find out about Jeff Verdon for a minute? Have you got a website that we can go to so we can find out more about you?
We have a website at www.jmvlaw, Jeff Michael Victor Law.com, and on that website are a list of all the upcoming seminars that I'll be doing. The cruises, my next cruise will be in September on the Crystal, part of the Freedom Fest group, and then I'll also be speaking in Las Vegas at the Freedom Fest conference this July, which is a land-based conference. But all that's on my website, and I've got a tab called Client Alert, and in the Client Alert tab are all these articles that I've written about many of the subjects I've talked about with you today, and other subjects which I think your listeners will find very interesting. If they want to get on the Client Alert mailing list, all they have to do is fill out the form that's on my website and put their information in, and we'll make sure when we send out our next Client Alerts that they get them.
That's www.jmvlaw.com.
That's correct, George.
Okay, and the other question that I had was, when you're in, are there any rules regarding the investment of trust money? I know when I was in law school and I studied trusts, it was always this prudent man rule. You have to, you have a fiduciary duty to invest these funds in a manner that's not going to be reckless and isn't going to squander the principal. So I wanted to talk about that. And my next question after that would be a comment you made earlier. If you were talking about the financial literacy, I guess, of high school and college kids, what would you recommend if someone's listening, a younger person like my engineer here, D? Where would D go to get financial literacy? What should he read or study so that he knows more about money? And then maybe you can answer those questions.
Well, taking your questions and the last one first, I just came off of doing a cruise for a group called the Real Estate Guys, which is a real estate-oriented group, and they're part of the Rich Dad, Poor Dad organization. And Robert Kiyosaki has written a number of wonderful books. Is probably the lead. I think it was the leading financial information book ever sold, which is called Rich Dad Poor Dad, and he has another book that he's just released called Second Chance. And if you go on to the Rich Dad Poor Dad, and I have no affiliation with this organization other than I've met the folks there, and the books are excellent books for any young person to read about the economy, why we're heading in the wrong direction, how they develop cash flow using real estate and other types of cash flowing assets. But just it gives a very, very good basic understanding of our economic system. And then Peter Schiff, who some of your listeners may know, has written some excellent books on the economy. He called the crash in 1999 and then again in 2007. And he has a wonderful book on economics. And economics has always been a very complicated topic for me. And Peter Schiff has written an excellent book on how economics and how the economy works, and it would be a great starting point for anybody who wanted to get a little bit more familiar with this area.
Peter Schiff, how do you spell that last name?
Schiff. Peter is a well-known economist. He ran for senator last election cycle out of Connecticut. He's somewhat of a controversial individual because he has predicted that the U.S. dollar is tanking and he prefers other world currencies, but he's called the last couple of crashes spot on. So if anybody has any interest, they should go to his website, peterschiff.com, and read his books and his writings, and they'll learn more about his philosophy.
Well, and finally, I just read in this morning's, I think it was this morning's Wall Street Journal, that right now equities are really high. We've had a huge run here since the bottom there in March of 2009. The market's doubled. Where would you be putting your money in the next 10 years, since the market seems to have come a long way in a short period of time?
Well, I'm not an investment advisor, but I have the benefit of sitting down with my wealthy clients, listening to their advisors, and I still like real estate. I think if you can buy real estate, cash flowing real estate, and you get long-term mortgages, and you pay off the mortgages with inflated dollars as the dollar begins to decline against the world's currencies. It's created more multimillionaires than any other investment. And I think real estate is the place to look. And there's all sorts of real estate: multi-tenant, single-family, apartments.
We've just come from a cycle in which half the country lost their shirts on real estate, and now you're saying get back into it. There's a lot of people that are going to say, "Uh-oh, not real estate." But now, I think that we've come such a long way from the crash that maybe now is the time.
The reason that the crash happened is because people gamed the system and broke the rules. And had that not happened, we wouldn't have had the crash. So hopefully they have the circuit breakers in place now so that won't happen again. But I think when your listeners read the Rich Dad, Poor Dad series of books, particularly his seminal book, and they read Second Chance, they'll get an understanding as to why putting your money in the stock market and keeping your money in dollars, U.S. dollars, that continue to depreciate against other currencies, although they're high right now. This too will pass. So.
Jeff, thank you so much. We've spent the last hour with Jeff Verdon. He is an estate planning lawyer from California. His website is www.jmvlaw.com. He lectures on this subject and is a practicing attorney. So thank you so much for joining us today.
My pleasure. Nice to be with you.
All right. Thank you so much. Well, this is George Yates, and we've only got a few seconds left before we go to CBS News Break. The last 2 hours we've been on Justice for All. And join us again next Saturday from 2 to 4 for another edition of Justice for All. You have a great weekend out there.